This is Barry Zalma on insurance. Every adjuster adjusting a liability claim will find an insured who has been sued, and that it is now the obligation of the adjuster to retain an attorney to defend the insured. In instances where insurance claims entail litigation, insurers must move quickly to engage counsel. When an attorney is retained to defend a person insured, the fact should be documented in writing by the attorney, the adjuster, and the insured who is to be defended. Before an insurer retains an attorney to represent an insured to defend the insured to claims of tort damages, that person should be certain the lawyer is competent to defend the insured. This can be accomplished by attending a trial conducted by the lawyer, where the person can evaluate the lawyer's competence at trial. If the option is not available, since very few cases go to trial, usually no more than 2% of all lawsuits filed, the claims person should seek recommendations from other insurance claims professionals who have retained the lawyer in the past, or the insurance company's list of approved defense lawyers who have been evaluated by the insurer's management. If the attorney is being retained for the first time by the insurer should obtain an engagement letter from the attorney setting forth the terms and conditions of the retention and signed by the attorney, the claims person, and the insured. If the attorney or law firm has an ongoing relationship with the insurer, only the person being defended needs sign an engagement letter. The engagement letter should, at the very least, list the following details. 1. The effective date of the agreement. 2. The fees to be charged, the units by which fees are calculated, usually in 6-minute increments or tenths of an hour, and a representation as to how often the attorney will submit fee bills, usually monthly or quarterly. 3. A description of reasons for discharge and withdrawal or conclusion of services. 4. A disclaimer of guarantee. 5. It should also outline the scope of the engagement. That is, it will specify that counsel will review copies of contracts and insurance-related documents he or she has been provided, review the files of the insurance broker and or the underwriting files of the insurer, attend, take, review, and analyze the depositions of the plaintiff and defendant experts and factual witnesses, as well as any other depositions agreed to be reasonably necessary, review any other files or documents that counsel, the claims person, and the insured defendant deem necessary. These might include those of plaintiffs and defendants as well as others. Review all pleadings and discovery that he or she, as well as the claims person and the defendant, deem necessary to present a competent defense. Provide his or her opinion regularly as to the case progresses and respond to inquiries from the claims person and the insured defendant. Consult regularly with the insured defendant and the claims person on various issues related to the case. Prepare regular reports to the insured defendant and claims person. With the approval of the claims person, file necessary motions to the court, including a motion for summary judgment, if appropriate. And if appropriate, attend mediation or settlement conferences with the insured defendant and claims person, after providing the insured and the claims person with opinions on the settlement value of the case. And if all attempts at settlement fail, present evidence at trial and defend the insured through trial and any necessary appeals. At retention, the claims person should, in writing, instruct counsel on the following matters. 1. The basic facts of the case learned in the initial investigation by the adjuster. 2. A brief description of the documents collected by the adjuster. 3. A statement of the date and time the summons and complaint were served on the insured. 4. A summary of the coverage and limits available to the insured. 5. Transcriptions of all recorded statements taken by the adjuster. 6. The insurer's requirements regarding billing by counsel. 7. The insurer's requirements regarding reporting from counsel concerning the litigation. 7. The insurer's requirements concerning work to be done by counsel, partners, associates, and paralegals. And 8. The insurer's requirements concerning limitations, discovery, and motion practice based upon approval of the insurer. The adjuster should provide the attorney with as many original documents as possible and keep copies for his or her own file. The claims person must understand that all documents collected by the adjuster are important to the defense. This includes the service copy of the summons and complaint, police reports, fire department reports, ambulance reports, doctor's reports, and files. The adjuster must advise the attorney of the exact date and time the complaint was served on the insured to ensure that a timely response is filed and to prevent the entry of a default. In most states, a defendant has 30 days from the date a complaint is served to file a formal response, 20 days in federal courts. Failure to formally respond to the complaint or obtain an extension of time to respond allows the plaintiff to declare the defendant in default and seek judgment as if the defendant had admitted all of the allegations of the complaint. Once a default has been entered, a judgment against the insured will follow unless good cause can be shown why the default should be set aside. Adjusters should make every effort to avoid putting an insured into such a difficult position by retaining counsel promptly. The insured must also report service of a lawsuit immediately, with advice as to the time and place the summons was served, the person who received the summons, and the reason for any delay in delivery to the insurer. The defense attorney should also have available a specimen copy of the policy, since its limits of liability will become an issue between the plaintiff and the defendant insured, a complete copy of the claim file, and a copy of the insurer's policy, if any, with regard to billing and case handling. If the insurer's billing and case handling policies are not available in written form, the initial retention letter should describe them, or it should be attached as an exhibit. The claims person must understand that an engagement letter is an effective contract between the lawyer and the insurer. As a matter of law, there could not have been an implied contract between plaintiffs and an insurer or the insured personally, because the court has decided the implied contract issue as a matter of law based on undisputed facts. The issue of whether there is a factual dispute regarding the existence of an implied contract becomes moot. Like an insurance policy, A lawyer's engagement letter will be read as written if there is no ambiguity and will be enforced by a court if there is ever a dispute between the lawyer and the insurer who agreed to pay the lawyer's fees. When the language of an engagement letter is clear and unambiguous, the defendant agreed to pay the plaintiff 5% of the gross income received by the defendant less any amounts clearly defined as reimbursements of your expenses, and defendant came forward with no evidence that any portion of the 4 installments totaling $1,055,000 that she received represented reimbursements for her expenses, the contract provided that the fee paid defendant was inclusive of any and all personal and or business expenses incurred by the defendant. It's a case called Kravitz versus Kaufman, a 2013 decision of the New York Appellate Court. In a situation where there is no dispute that the parties entered into an enforceable fee agreement, the terms of which were set forth in an engagement letter, a court will enforce the agreement. When the defendant responded to requests for admission, in which she acknowledged signing the engagement letter, receiving itemized invoices for services rendered under the engagement letter, and paying some of the fees and expenses charged by the lawyers, the fees were determined to must be paid. This was Jochum versus Listati, a 2019 decision of the Ohio Court of Appeal. An adjuster and the attorney should meet in person to reach an agreement that they will work as a team in handling the case through trial, and they are both in agreement with the terms and conditions of the lawyer's engagement letter. Whenever an insured is sued and requires a defense, or the insurer is sued, the insurance adjuster and defense attorney must understand their respective roles in preparing the case for trial. They must develop a rapport with each other and with the insured person or entity that is being defended to make communication easier to maintain. Bad faith lawsuits and poorly tried bodily injury cases seem to arise when the adjuster and the defense attorney fail to communicate regularly with each other and the policyholder. At the first meeting, the attorney and the adjuster should agree on the division of labor with regard to the preparation of the case according to their respective training and experience. Counsel and the claims person should reach an agreement regarding the handling of the case. Claims adjusters often mistakenly leave all investigation tasks to the attorney. Most adjusters are also investigators and are trained to fulfill the duties of an investigator within their narrow field of expertise. Therefore, the adjuster should do as many informal interviews of witnesses and parties as possible and provide the results to the attorney. The attorney should limit his or her investigation work to the preparation of witnesses before the trial or deposition. Work that is usually done by the attorney or by a legal assistant includes meeting with the insured to obtain facts for answering interrogatories, interviewing the insured and key witnesses, including getting recorded statements from each, collecting and preparing documentary evidence such as medical records, police reports, and employment records, preparing responsive pleadings to lawsuits, preparing for and taking depositions of the party's plaintiff or defendant and those of independent witnesses, preparing written discovery, such as interrogatory requests for admission and requests for production of documents, preparing, filing, and arguing motions with the court, preparing briefs for mediation, attending and negotiating potential settlement at mediation or court-ordered settlement conferences, preparing motions in limine before trial, preparing trial briefs for presentation to the court before trial begins, preparing evidence and witnesses for trial, and preparing evidence and arguing legal issues at trial. This video was adapted from my book, Zelma on Insurance Claims, Part 108, Second Edition, which is the 8th part of the 10-part treatise, Zelma on Insurance Claims, available as both a Kindle book and a paperback from Amazon.com. If you found this video to be interesting or useful to you or your colleagues, please pass it on. It's free. And please subscribe to my Rumble channel, my YouTube channel, my Substack reporting channel, and my blog so you can be advised of future blog postings and videos. Thank you for your attention.